Universities are required to commercialize or exploit inventions. In some cases, such requirements or obligations may act as incentives for institutions to make considerable efforts to commercialize their research and development results and devote human and financial resources to such tasks. Exploitation requirements may, in some cases, also go hand in hand with requirements to report and or disclose any inventions or IP rights to the research funding agencies. Despite difficulties in monitoring such provisions, they have proved useful in some countries to encourage technology transfer. Again, requirements to commercialize inventions. In a number of countries' legislation and in the regulations of some research funding agencies, universities are required to commercialize or exploit inventions. In some cases, such requirements or obligations may act as incentives for institutions to make considerable efforts to commercialize their research and development results and devote human and financial resources to such tasks. Exploitation requirements may, in some cases, also go hand in hand with requirements to report and or disclose any inventions or IP rights to the research funding agencies. Despite difficulties in monitoring such provisions, they have proved useful in some countries to encourage technology transfer. Safeguarding the public interest. The ultimate goal of policies and legislation in this field is generally to facilitate the transfer of technology to industry in order to ensure its commercialization for the benefit of the public interest. With this in mind, and considering that research is often funded by public resources, policies often contain provisions to ensure that the public interest is safeguarded. For example, in some countries, universities have a specified time during which they may exercise their ownership. Otherwise, title is transferred to the government or funding agency. Again, for example, in some countries, universities have a specified time during which they may exercise their ownership. Otherwise, title is transferred to the government or funding agency. Moreover, in some countries, the government reserves for itself a royalty-free license to practice or have practiced on its behalf. And publicly funded invention in exceptional circumstances, also called Martian rights. Guidelines and codes of practice. Some governments have issued guidelines, codes of practice, or a set of principles to supplement laws or provide support to institutions on the exploitation of IP rights. The aim of such guidelines is generally to ensure that universities have access to best practices for the identification, protection, and management of IP rights. Programs to support the establishment of technology transfer offices. In a number of countries, programs have been introduced to fund the establishment of technology transfer offices. Technology transfer offices are broadly defined as bodies that are in charge of managing the transfer of technology to industry and are often in charge of managing the university's IP assets. Ideally, technology transfer offices would be self-sufficient and eventually generate additional income for the university. However, experience shows that not all technology transfer offices manage to become self-funded, and even when they do, startup funds are generally required for a number of years. In some countries, governments support the establishment of technology transfer offices by means of financial and or technical assistance. National patent offices, in particular, are often called upon to provide technical support to technology transfer offices, particularly in the early phases. Strengthening education on IP. The need to strengthen IP education within universities is also important, not only among law and business students, but also among scientists and engineers so that researchers have become acquainted with how the intellectual property system works. Spreading the use of patent databases by science students as a source of technology information is a key measure for enhancing their knowledge of latest technology developments and bringing scientists closer to the intellectual property system. Grace period. The publication of research results prior to filing a patent application may compromise their patentability, as a subsequent patent application would no longer meet the novelty requirement. As a result, some countries have provisions for a grace period, that is to say, a period during which an invention can be disclosed by a researcher, for example, through publication without compromising the invention's patentability. This is thought to be a useful mechanism to facilitate patenting by researchers who are under pressure to publish their results. In countries where a grace period exists, researchers may publish the research results and subsequently submit their patent application within a specified time frame, generally 6 months or a year. Detractors of the grace period, however, argue that the introduction of grace periods increases legal uncertainty. Countries' legislation differ significantly on this issue, and grace periods exist in different forms in some countries, e.g. US, Japan, Russia, and China, but don't exist in others, e.g. countries that are members of the European Patent Convention. Patents may be denied to inventors who have relied on the grace period's provisions when they apply in countries where such provisions don't exist. Again, patents may be denied to inventors who have relied on the grace period's provisions when they apply in countries where such provisions don't exist. Framework for the establishment of spin-offs. The creation of spin-offs is considered an important avenue for commercialization of new technology, particularly when the nature of the technology is such that no current player in a particular market would be willing to take the risk of taking a given invention to market. National policies may have to address issues that may arise in relation to the establishment of university spin-off companies. For instance, it may be necessary to determine whether state-owned universities are entitled to own equity over spin-off companies, and whether, in which circumstances, state-funded university researchers may participate in private enterprises. More on this below under Section 2. Seed funding for spin-offs and startups. Given the financial risks involved in the establishment of startup companies and university spin-offs, it's often difficult to find the necessary seed funding in financial markets. In some countries, governments have established competitive funding mechanisms to which startup companies may apply to obtain venture funding. The existence of such funding mechanisms, particularly for the establishment of new technology-based firms based on university patented technology, can have an impact on the likelihood of such enterprises developing and surviving beyond the startup phase. University policy on intellectual property and technology transfer. Clear and transparent IP policy. A crucial first step for any university intending to build partnerships with the private sector for technology transfer of patented inventions is to have a clear and transparent IP policy that is formally approved by the university authorities and available for consultation by researchers and external parties or external partners. In many cases, IP policies are the result of a participatory process involving all the main stakeholders within the institution. University IP policies generally cover all IP rights, in particular patents and copyrights, but may also regulate the transfer of know-how. The IP policy should be a dynamic document and can be reviewed if necessary or as necessary, providing clarity on a number of issues. Some of the main objectives of an internal IP policy are to provide rules and guidelines for the commercial exploitation of IP generated within the university, ensure that discoveries, inventions, and creations generated by staff and students are utilized in ways most likely to benefit the public, establish ownership criteria, define the responsibilities, rights and obligations of all stakeholders, develop basic guidelines for the administration of the IP policy, and finally define rules for benefit sharing if the commercialization of IP generates income. Criteria for ownership. While the general provisions on ownership of research conducted by the university researchers with public funds are likely to be addressed by national legislation, the university's internal IP policy generally reaffirms the main principles, states the university's intentions with respect to the exercise of, while the general provisions on ownership of research conducted by university researchers with public funds are likely to be addressed by national legislation, the university's internal IP policy generally reaffirms the main principles, states the university's intentions with respect to the exercise of its IP rights, and addresses a number of particular circumstances such as cases in which IP rights are generated as a result of research sponsored, all or in part, by private sector companies in the framework of research contracts, cases in which IP rights are generated as a result of funding by public sector agencies that might have specific contractual terms associated with the funding, cases in which IP is generated by researchers who are not bound by employment contracts such as undergraduate or postgraduate students, cases in which inventions are developed in partnership with third parties, individuals, or institutions. Income distribution or royalty sharing. Provisions on income distribution or royalty sharing are a key element of most IP policies. Income distribution provides an important incentive for researchers to ensure that they disclose their inventions to the relevant body and seek to find the best avenue for commercialization. Again, income distribution provides an important incentive for researchers to ensure that they disclose their inventions to the relevant body and seek to find the best avenue for commercialization. Provisions on income distribution generally define clearly what type of income is to be distributed, and generally applies not just to royalties but to any other lump sum or milestone payment made to the institution for the commercialization of technology. Common practice in this regard is that income generated must first cover any expenses related to the protection and exploitation of the IP, and the net income is subsequently distributed between the researchers, the department, the university, the technology transfer office, and or other stakeholders in percentages that are established in the policy. IP policies often establish revenue thresholds, and the percentage received by the researchers decreases as total net revenue increases. University IP policies may also define how decisions are to be taken on how to split the income when more than one researcher is involved. Conflicts of interest. A conflict of interest occurs whenever two or more goals or ends can't be pursued simultaneously, and they are in potential competition. Again, a conflict of interest occurs whenever two or more goals or ends can't be pursued simultaneously, and they are in potential competition. It has been described as a situation in which a public obligation competes with financial interests. Productive interchange between the university, the faculty, or other employees, and the private sector may sometimes engender conflicts of interest. Again, productive interchange between the university, the faculty, or other employees and the private sector may sometimes engender conflicts of interest, in which legitimate but disparate goals of some of the actors involved may be in conflict. In particular, universities are often concerned that research is not skewed towards the interests of private companies,